you will hear or have heard the statement by many of us who are opposed to death by doctor-prescribed death, something the opponents want to call death with dignity, but we don't want to call it what it is, which is doctor-prescribed death. You will hear us say that this puts us and our society on a slippery slope towards the development of policies and programs regarding end of life that we simply don't think it is right for us to be on. And as I was thinking of this idea of a slippery slope, I wanted to relate to you a true story about my involvement in 2000, of the year 2000, with a very small group of people who were at that point doing the best they could to oppose medical marijuana. I don't know how many of you remember the political fight over medical marijuana, but it was sold to the people of the state of Colorado on the basis that there were a handful of terminally ill cancer patients, and couldn't we just have the heart to let those handful of terminally ill cancer patients ingest marijuana during the last few days of their lives? Well, after the medical marijuana initiative was adopted by the people of the state of Colorado, over the course of time, according to former Attorney General Suthers, there were 125,000 medical marijuana permits issued, 75% of which were issued to people between the ages of 18 and 24 who claimed to have bad backs, as I at least understand it. That's the slippery slope concept that we're on in this doctor-prescribed death as well, because you've seen what's happened with marijuana in our state. I, for one, am outraged, is the only word I can think of, over this state's acceptance of legalization of marijuana. It makes us the laughingstock around the world. We were in Israel 2 years ago, and would introduce ourselves to people as from Colorado. Oh, you mean that's where marijuana is legalized? That's what people know us for. That's what we're famous for. And today, this pressure in the state of Colorado by progressives or liberals continues to mount for a way, legally or by even amendment to the Constitution, to allow doctors to really abandon their historic roles as healers of people and instead help them to be, or authorize them to become, killers of people instead. Now, I'm supposed to outline for you a little bit about the legal background. First of all, it's very well settled, as Carrie articulated, that competent adults, and the word competent is very important here. That means you have the ability to make a decision of significance regarding your personal possessions, health, property, and effects. When you those of you that have gone to the trouble of creating a will, of executing a will, or all the documents that you might execute in connection with a will, trust and so forth, you have to have competence in order to be able to do so. You have to have the capacity to know who you are, know what you own, know who the objects of your bounty are, your children and others who you want to leave your property to. You have to be able to make those decisions knowingly and with competence. And so you have to be a competent adult to make a decision about life or about death. Competent adults have the ability to either receive or refuse medical care and treatment. Carrie outlined this very well. We do not have a duty or an obligation to accept and receive medical care or treatment if we choose not to do so. In 1983, my oldest son was terminally ill from a rare form of leukemia that had not been identified by doctors in more than a dozen cases in its discovery, none of which had been survivors. All of the patients who had been afflicted with this form of leukemia had not survived. Toward the end of his life, he and we made the decision that it was no longer desirable or feasible to keep him on life-sustaining drugs and other kinds of things that kept him alive. And so we decided to end the treatment that he was being provided at that point in time. It was a very sad and a very difficult and a very significant emotional decision for me and my family at that point in time. It was a decision that we made and we chose to make as we had the right to do. But the flip side of that is that no one has the right to take the life of another human being. Carrie said it correctly. If another person takes the life of a human being through other than natural causes, it is one of two things. It is either homicide or some form of homicide, or it is suicide. And I beg to differ with Carrie on this. Suicide has been in our society illegal. It has been prosecutable as a criminal offense. The tides of our world are changing remarkably and dramatically. We all know that, and we've all seen that over the last 15 years in our society as progressive efforts in such things as marriage and religious liberties, and now even life and death decisions, abortion, and issues like that have just taken on incredible power and force of their own. Over the course of the Supreme Court, the United States Supreme Court has decided 4 cases on which the right to die have been involved. And I'll give you more details of those. Actually, the details of those are in a paper the Centennial Institute published that I authored, and a colleague of, just happened to have it there, policy brief, just happened to have a copy of it here. A colleague of mine, Natalie Decker, authored a couple of years ago, and we're in the process of updating it. But the Supreme Court has authored opinions in 4 cases that involved the right to die, 3 of which involved doctor-prescribed suicide. In all of those cases, the Supreme Court has confirmed that the protection and preservation of human life is a legitimate state interest, and that there is no 14th Amendment, due process, equal protection, or any other constitutional right to physician-assisted suicide or to euthanasia. In fact, in one of those cases, the Nancy Cruzan case, the Supreme Court said, all civilized nations demonstrate their commitment to life by treating homicide as a serious crime. Moreover, the majority of states in this country have laws imposing criminal penalties on one who assists another to commit suicide. We do not think a state is required to remain neutral in the face of an informed and voluntary decision by a physically able adult to starve to death. In other words, there is no right to physician-assisted suicide or death by doctor. The court also, interestingly enough, acknowledged in this Cruzan case that family members, in some circumstances, will not act to protect their ill family member, and that an erroneous decision to withdraw life-sustaining treatment cannot be corrected. It is the end of the story for that particular person. It cannot be altered. It cannot be changed. They put their finger on it, just as Carrie was identifying. There are motives and motivations for the death of others that are not based on the goodwill, the good intentions, or the desires of the person whose life is being terminated. The other, perhaps most significant right to die case by the United States Supreme Court is called Washington versus Glucksberg. Now, these are older cases, and I'll tell you a little bit more about this case in a moment, but I hasten to add to you that the most significant development in First Amendment, religious liberties, sanctity of life, marriage in the family, and assisted suicide issues, the most significant development in the last 20 years is the death of Justice Antonin Scalia. Justice Scalia was a genius, an incredibly brilliant, spoke here in this very room, Jeff, several months ago, I think it was this very room, and I was privileged to hear him on that occasion later at a lunch here at CCU. A brilliant jurist who was characterized as being an originalist. He characterized himself as an originalist. He would say, if it's not in the Constitution, it's just not there. You can talk all you want about rights that ought to be in the Constitution, but if they're not there, they're not in the Constitution, they're not rights that are guaranteed by the Constitution of the United States. A lot of the progressive, left-wing, liberal media and others would scoff at Justice Scalia and try to characterize him as an ignorant buffoon, but the man was a genius, and he pulled the left-leaning members of the Supreme Court back over toward the center with his brilliance and with his arguments and with his wit and his wisdom. That's no longer there. My hope and prayer is that Justice Alito and even Justice Thomas, who curiously enough, the day after or the week after the death of Justice Scalia, spoke up and asked questions in a Supreme Court oral argument for what the press would say is the first time in history. I would say he doesn't need to know ask questions, because he already knows what the answers are to the questions he's going to ask. In the Washington versus Glucksberg case, the court held that the 14th Due Process Clause does not provide a fundamental liberty interest in doctor-prescribed suicide. This is interesting because for those of you that are constitutional law buffs or scholars, the Supreme Court held just the reverse in Roe v. Wade in 1973, and that was that the 14th Amendment had hidden in its penumbras, and penumbras is a fancy legal word that means vibes or emanations. Woo, I can hear them coming now. In the emanations of or penumbras of the 14th Amendment, there was hidden a right to privacy that guaranteed people the right to abortion in almost all cases. We've been fighting against that Supreme Court decision since 1973. But the Supreme Court has decided that's not the case. There is no such 14th Amendment right for doctor-prescribed suicide. How Justice Scalia's death may change that, may tip the balance towards a physician-assisted suicide remains to be seen. It's why, I parenthetically add, it is so important for you to speak up to your senators and congressmen and to others about the nomination to the Supreme Court that President Obama has made, that should not be confirmed by the United States Senate. Under no circumstances should it be confirmed until there is a new president in office. In Gonzalez versus Oregon, which is a more recent case involving the issue of laws of right to die, you heard Carrie talk about the Oregon law, and frankly, she's very correct. It's empty of any reporting requirements, just as the Colorado law would be. There would be no reporting requirements. Therefore, nobody knows exactly what's happening, who's dying, or why they're dying, or when they're dying, or how they're dying, when the medication is being prescribed, when it's being taken, or who is even taking it, and the doctor is not even present when that happens. In this case, then Attorney General Alberto Gonzales sought to adopt a regulation, and did adopt a regulation which characterized, which found Oregon's assisted suicide law was against the Controlled Substances Act, because the use of the drugs that were being prescribed in Oregon were controlled substances, were scheduled controlled substances. Supreme Court, in hearing that case, didn't find that there was a right to or a right not to assisted suicide. It simply said that Gonzales exceeded his legal and constitutional authority. There's no right in this Controlled Substances Act for him to reach the conclusion that he reached regarding the use of those drugs. Quite interesting, I think, in light of the climate in today's constitutional arena, whereby President Obama and others under his direction are simply inventing laws without any legal authority and not being held accountable for it. So no Supreme Court case stands for the proposition that life does not deserve to be protected, even if someone does not think that life is not intrinsically valuable. And I'm a big buff of religious liberties and First Amendment rights. I rest on the statements of the Bible in Genesis 1:1, which goes as follows: Bereshit bara Elohim hashemayim v'ha eretz, which means in the beginning God created the heavens and the earth. God created all life. All life is intrinsically valuable to God. He is the God of life, not the God of death. I have an interesting quote for you to close with from an individual who is an oncologist, a former White House advisor, and brother of Chicago Mayor Rahm Emanuel, who you probably all well know and identify as one of President Obama's chief advisors, former advisors. Dr. Ezekiel Emanuel says, quote, "Once legalized, doctor-prescribed suicide and euthanasia would become routine. Over time, doctors would become comfortable giving injections to end life, and comfort would make us want to extend the option to others who, in society's view, are suffering and leading purposeless lives." Think about that for a moment, because once this physician-assisted suicide is adopted in the state of Colorado, as is the case in Oregon, in California, and the other two states where it has been legalized, there is no end to the malevolence that will occur in our society. And what began as a purported effort to help those suffering with unbearable pain, like those few terminally ill cancer patients who only needed a little bit of medical marijuana to survive their last days will be an absolute disaster, resulting in the murder of hundreds and thousands of human beings whose lives are intrinsically valuable.